Cancellations with clients can feel like the worst thing in the world. It's something that can keep business owners up at night, running through all of the what if scenarios in your head, especially if you are the one canceling the contract with them or you're thinking about it. I've been there. I seriously have been there when I felt the need to cancel a client contract, and I had so much anxiety about it. It could be for a number of reasons, like a family emergency, or the client has been a nightmare to work with and you're ready to set boundaries, or they deliberately breached your contract, or maybe you have decided to go a different route with your life and you're trying to you tie up all the loose ends with your existing clients and you want to move on and, give them to somebody who would better serve them. And you're canceling on them. Obviously, this issue is a touchy subject because no one ever intends to enter into a contract to terminate it before the parties have completed their performance. You don't do that. I would hope not, or you're a really malicious person. But sometimes canceling is just inevitable. It's life. Life happens. But canceling can lead to bad taste in your clients' mouths, yucky feelings all around, and the dreaded bad reviews, which is worst case scenario. So let's get into in this episode how to cancel on your clients legally and make sure you're protected as the business owner at the end of the day.
You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. I am an attorney, but I am not your attorney. All legal information I talk about in this episode is intended for the masses and a large variety of different businesses. Please seek out another attorney in your city and home state if you need specific legal advice related to your unique business. Okay, let's get back to it.
First, let me reiterate that cancellations can be tricky. And if you are the one who is canceling the contract, you want to be uber delicate about it. Uber. Now, say you are in the middle of, I don't know what to do. I really need to cancel this contract. Whatever the back-end reasoning is, my first piece of advice is to document that decision to cancel in a signed agreement and explain what is going to happen to any fees your clients have paid thus far. What I mean by this is you have to sign a cancellation contract. You not only need to explain in your existing contract what would happen if you have to cancel. We call this a cancellation of services by company clause. We have two cancellation clauses in all, if not 99%. Sometimes they're termination clauses, but we have a cancellation by client clause and a cancellation of services by company clause. Those two clauses in all of our full-length service contracts, primarily for people in kind of event, booking out in advance type of industries. And the reason being is because life happens and there's just situations that could occur whereby your clients need to cancel, and that's kind of a different situation than if you need to cancel. And that's just because of refundability purposes. If they're voluntarily canceling, that's different than you having to do it for a family emergency and you're going to try to find someone to take their place, yada, yada. All of that is in a cancellation of services by company clause. But that will alert your clients and notify them of what you guys have agreed on contract-wise, but you got to terminate that contract now. So remember that you absolutely need to have a cancellation agreement. It's a separate 1 to 2 pager document that will be sent out to your clients as a standalone contract. It terminates and supersedes the previous service agreement that you guys have signed with those other cancellation clauses I was talking about. But it also supersedes any oral agreements you had with them, which is important because I would hope that you're getting on the phone with clients if you're the one canceling, or at least a Zoom call. I don't love emailing back and forth with clients. if you're the one canceling. But if there's no way you can get on a phone with them, you could email back and forth. And I would say if you're canceling and this is like months and months out or a year out, you could probably email. But again, you got to be delicate with those emails. Like people can read into emails. They can't really read into the way that you're verbally explaining things to them and your inflections in your voice and your emotions in your voice when you're talking to them over the phone and body language if you're in person or on Zoom. So choose your own path here, but Zoom, phone call, best practices to cancel on a client. And then all of those things that you said orally, they need to be summed up in a cancellation agreement. And in that cancellation agreement, we have cancellation contracts here at the Legal Page. Ours always say that they supersede any other written or oral agreements because that's important. What you put in writing and what all of the parties are signing off on for the cancellation and termination should be what holds up. Now, let's probably answer your next question, which is how should you send this cancellation contract to your client? If you are canceling on a client due to the client being in breach of your contract, they're a nightmare to work with, like communication-wise, it's just not working out. Here's how I want you to approach that situation legally. Before you cancel the contract, reach out to your clients multiple times, like try to document it, get that proof. Issue them warnings and explain that if you have to cancel the contract, they will not receive their retainer back because they're the ones that have breached for XYZ reasons. You want to be professional in these situations and gentle about how you go about it, but firm enough that they know you're upholding your contract that you all have signed. However, if you cancel due to kind of lack of response from your client, you are in the right to keep your retainer. And in situations like this, it's best to cancel because your clients are preventing you from fulfilling your obligations under the contract, and the chances are that there is going to be monetary disputes down the road. If you're already in a sticky situation now, it's only going to get worse later on. So keep in mind that if you decide to keep the retainer amount or any of the amounts that they've paid you, you might end up in like a chargeback scenario or even threat of lawsuits. Although you're in your right to keep the retainer, just know that some service providers may not want to go through with a legal battle. And if you're in that boat, you may want to return a partial amount or the full amount to avoid a legal dispute in this case. Now, I personally don't do that. And I'm kind of a no-holds-barred type of person, like, don't mess with me. And also, I would hope that a lot of professionals feel empowered and emboldened to like do this as well. I would only return a retainer if I have done no work. Like no work for this client. And it's super early on in the process. Like if I am a month into this, I've maybe sent 5 emails back and forth, haven't gotten anywhere with them, like tried calling them, nothing. And I can't even move forward with my services. This is probably like a full service wedding planner situation. Like if it's that early on in the process and they're not upholding probably your communication clause in your contract and working together clause, like all of the processes and procedures that you have in your contract, if they're already in breach, it's just going to be a snowball effect. They're going to continue to be in breach throughout the duration of your relationship together. So if it's that early on in the process, that is where I would just have a clean break, cancel on the client, give a full refund. Even though you've spent a few hours, it's okay. Just like sunk cost there. Okay, in another scenario I want to throw at you in this situation, maybe you try to have your client sign a cancellation agreement and they don't sign it, or they like open it, you haven't heard from them, like they're already ghosting you. This happens quite a bit where people are like, I want to cancel on this client because they're ghosting me and like I'm done. I've done everything. I've sent them like 20 emails, 20 texts, phone calls, like I've called people that they know, I've DM'd people on Instagram that they know, like nothing. Then you're in the right to cancel, they're in breach, and you could try to send a cancellation contract, which is what I would do. I would absolutely get it prepared and send it over to them. But the chances of them signing it if they're in that situation are like slim to none. However, they should be receiving that contract from you and an email requesting their signatures on the agreement and notifying them of the termination of the contract. And then you would send follow-ups, and probably after 3 times of following up for not signing the cancellation agreement, you unilaterally cancel the contract. And that's where you would send an email, and maybe even if it's like high stakes retainer, like thousands and thousands and thousands of dollars, then you probably want to send a certified letter in the mail surrounding the unilateral termination and all of the documented steps that you took to contact them. And here, as a smart business owner, it's also important to think about when you want to cancel. You should be canceling as soon as you know you need to. I've seen over my past few years in the online industry, especially in wedding and event industry, where people may need to cancel mainly because of family situations that have come up, or they're preparing to build upon their family and they are waiting and they're not telling their clients. And I'm like, as soon as you know that you may have to cancel, try not to leave your clients high and dry a couple months before, unless it's totally unavoidable. Like if you get in a massive car wreck or you're injured or someone really, in your immediate family passes away. Those are unavoidable situations where sometimes it's just life. You have to cancel. But if you are preparing for a potential cancellation months in advance, notify them that it might not happen, but it could happen. And then give them options. Be a good human is what I'm trying to tell you. Don't just hold on to something that could occur if you're already thinking that a cancellation might come up. And the same here goes for clients who are berating you or they're being extremely difficult and you already have in the back of your mind, or they're ghosting you. And then you have in the back of your mind, I think I may want to cancel with them at some point. How bad does this have to get until I cancel? I don't love those scenarios because although the client may be in the wrong or in breach of contract later down the road, multiple times in breach of contract, your integrity of a business owner needs to be intact way more. And I like to think about it if the roles were reversed and someone was canceling on you. Tensions are already high in those cancellation situations. So canceling sooner rather than later is going to mitigate some of the fallout there. So be very, very aware of that. Okay, so for the most part here, I got a little bit off topic, but for the most part, what we just went over was when your clients are in breach of contract or they're kind of those nightmare client situations and you want to cancel, how do you do it legally? Those are the steps we just went through. Now, if you're canceling due to extenuating circumstances, like a family emergency, let's say, that happens so unknowingly and it's unavoidable, here's how I would advise you to approach the situation. Some of the ways to handle this with your clients is just by being open and honest with what happened. They do not need intimate details, but it's good to give them enough details that they can fully grasp your situation and be empathetic towards it. Give them an overview of what happened and let them know as soon as possible. Again, this goes back to leaving them high and dry. You kind of are leaving them high and dry in this situation, but these extenuating circumstances made it unavoidable at that time. So the more notice and communication, the better here. And try to find a replacement. At least give that option to your clients. If you're a professional service provider and they worked with you, who can you find that is a trusted, confident colleague in the industry? Who is someone that at least can do part of your services and you can do the rest, if you're a photographer later down the road? All of that is so helpful to your clients, at least the option of it. Remember, you're the one canceling, so you can't force them to go with a replacement. Although it might be a contractual obligation, we here at the Legal Page believe that needs to be a mutually agreeable event. So if you have kind of concrete language that says you have the right to find a replacement unilaterally, I don't love that. I don't love it because your clients booked you, they didn't book this replacement. I would say make it optional by a mutual agreement of all parties involved. If you do find a replacement, of course, make sure it's someone who is reputable. They are going to do a stellar job. Make sure your client approves of them. And that's the key here, right? They chose you, not the replacement, mutual agreement. So send them the services, this person's services, send them their portfolio, what have you, have them jump on a phone call, make sure that they're comfortable with this person before moving forward with them coming in your place, but you're still under contract. It's kind of like this replacement's probably going to be a subcontractor for you, unless you want to completely cancel your agreement and this other service provider is I would be more comfortable having my own contract with these clients now. Then that's legally speaking, that's the most clean way to do it. But you absolutely can have them subcontract for you underneath, and that that is easier for the clients because the clients are already contracted with you. And then you're just kind of dealing with the replacement as a contractor. And then lastly, if you're the only one who can do the work and no replacement is possible, then this is where I always tell people, you got to return everything money-wise. You're the one canceling on them. You have to put those clients legally in the situation that they were prior to contracting, even if you've done a bunch of work. I know that's just not fun. That's why you need an emergency fund for your business, because it's the fairest outcome for both parties. It puts your clients in that same position that they were prior to contracting. That's where you want them to be so that they are not upset. Give them their money back if you're the one canceling for an unavoidable, unforeseeable, tragic situation and extenuating circumstance. That's the only time I would give all of the money back, or at least a very hefty partial refund. I know some people like to keep money for services they've rendered. If you're a photographer and you're canceling and you did an engagement session that was a part of your services and now you're canceling, I'm just eat it. Eat those costs. You're the one canceling now, but you could try. You could try to give a partial refund. Legally, I don't recommend it. Last but not least, apologize a lot. Just apologize. Be a human. Give the utmost customer service when you're canceling. Make them understand where you're coming from, or hope to goodness that they understand where you're coming from, and just really try to make these situations happen very little. Now, before we end this episode, I want to share what legal language and clauses need to be in a cancellation contract. This is that 1 to 2 pager short form document that you're going to send to your clients when you are canceling as the service provider. If you're a TLP customer and you already have cancellation contracts, amazing. I'm so glad you have that in your legal toolkit. These are contracts. The contract bundle that we have at thelegalpage.com comes with a cancellation by client contract and a cancellation by company contract. They kind of have a little bit different language regarding what you would do, and I've explained that to you here based upon these situations. But if you're canceling for kind of an extenuating circumstance, or your clients have breached the contract, there's certain things that you absolutely need to make sure are in this. It's more of a settlement agreement, I tend to think, especially if there's breaches occurring and you're canceling, it is a settlement agreement. It's a way for the parties to agree to part ways and move forward. So if you're a TLP customer, know that you already have this contract, but I would just take some time after today's episode to review it and make sure you're 100% clear on your policies. Okay, so in your cancellation contract, have the following clauses. This is like a checklist. Come back to this checklist time and time again. Do you have a kind of forfeit of fees paid? Forfeit of retainers, refund of retainer, refund of all fees paid. I don't know how you delineated that in your original contract. We call them retainers here at the legal page for a variety of reasons, but maybe you have a different existing contract and you don't use TLP contracts and you call them, booking fees or other fees too. Then it would be a forfeit or a refund of fees paid. Okay. That's a clause that's the very first clause. That's what clients care about the most. Then Company's release of contractual obligations. That's a clause that needs to be in there. Of course, when all parties have signed this cancellation contract, you're released of any performance obligations under that original contract. Then these are very standard. So a mutual release of claims means that the parties have settled on this cancellation and they're not going to sue each other later down the road. Representations and warranties are really important. And then confidentiality clause. A confidentiality clause means that this cancellation and how the parties have decided to terminate their relationship should stay confidential between the parties. That is different than a non-disparagement clause. I'm going to talk about that in a second. And then venue and jurisdiction and severability. That's really important. Those two boilerplate language clauses. So those are the 7 clauses that you need to be in that contract. In your cancellation contract, though, I recommend staying away from a non-disparagement clause. And this is a biggie, and people ask about it all the time. They're like, I want to prevent my clients from a bad review if they sign this cancellation contract. So the confidentiality clause that we have in our cancellation contracts prevents them from disclosing to the public or to anyone else what you did. Did you give a refund? Did you give a partial refund? What was the facts and circumstances surrounding this termination of your guys' relationship? They can't disclose that. That's like signing an NDA. It's a confidentiality clause in your cancellation contract. But a non-disparagement clause is different. It is an attempt to prevent clients from giving bad reviews online or posting anything testimonial-wise about their experience working with you. First off, putting this type of clause in your contract is not a good idea because it looks bad on its face. You're basically telling them you don't like bad reviews or you're worried about it. I feel like you're giving them a playbook to give you a bad review. Sorry. I'm very heated. I don't love them on their face. I'm like, why would you put this in your contract? Don't tell them to potentially do it. And then second, you really actually can't keep your clients from writing a bad review if it's a truthful review. If you've done a bad job or they have something to complain about as a customer, that's their First Amendment freedom of speech right to say something. And it's in all consumer protection laws in every single state across the United States. They have the right to write a review. To defame you or have libelous comments about you that are completely false and untrue, that is something different. But if from their perspective, they are saying something that is truthful, that actually did happen, and it's their perception of it, they can do that. They have the right to post that. So non-disparagement clauses really only belong in business-to-business contracts, not in client-to-business contracts, because businesses can agree not to disparage one another. But clients and consumers have the right to write reviews. And a client to business contract is very, very different. So just remember, non-disparagement clauses do not belong in these types of contracts. And then lastly, just remember, if you go above and beyond for your clients, you really shouldn't be worrying about bad reviews anyways. If they write a weird review for you after canceling a contract, I bet that review at least was not as bad as it would have been if you would have stayed with that client and they would have had even more reasons to put in that bad review 6 months down the road because you decided to cancel then and not now. Just to give you a little bit of insight into where my brain is at there. All right, to wrap up this episode, cancellation agreements are important to protect yourself. If you have to cancel an original service agreement, you want clear language regarding any type of refunds, full or partial, fee forfeiture, and confidentiality in your cancellation contract so that you and your clients know exactly what is being terminated and who is terminating what and what obligations are released, what payments are released, so on and so forth. And finally, I hope your biggest takeaway from this episode is that there will be different scenarios, cancellation-wise, that come up for business owners. This is especially true when it comes to us as service providers canceling for our clients. And although it may not have happened to you yet and you've never had to use a cancellation agreement, like power to you. I mean, if you made it through the past 3 years without using a cancellation agreement, I'm like, who are you? Let's talk. Slide into my DMs. What type of business do you run? And like, tell me all your business policies. Tell me all your secrets. Most of us are a little bit more accustomed to this because we had to do reschedulings and cancellations like crazy in 2020 and 2021. But if you're a newer business owner and it hasn't happened to you yet, it's just super important to be informed on how to be a smarter, better business owner and how to do this legally if the situation should arise. Because you, your family, and your mental health should always be number one priority. And I wholeheartedly believe that. So you have the right to cancel a contract if something were to go wrong that you did not foresee going wrong at the time of contracting. Make sure that you are fully ready for cancellations with a cancellation contract when you need it. You can find our bundle that I talked about in this episode. They're called cancellation contracts at thelegalpaige.com. That's thelegalpaige.com. In the search bar, you can just type in cancellation contract and that will come up. And it includes both, whether you're canceling on the client or vice versa. It's great to have in your legal toolkit. I highly recommend that, along with some contract addendums and amendments for when you need to utilize that. And before we end the episode, the last thing I just wanted to say is be sure to join the Legal Paige Facebook group, because we have thousands of entrepreneurs just like you in there getting real-time answers to their cancellation questions. And we actually have cancellation questions probably come up more regular than any other question in that group. That is actually where the inspiration for this episode came from. We were having, I think, 2 weeks straight of like 15 different types of cancellation scenarios. And my legal team and I were in there answering the questions. And we were like, we just need like an episode that we can really summarize every type of possible situation and what we would suggest legally on how to confront those situations. And so just know that you can go into that Facebook group, you can ask a question surrounding your unique cancellation situation, and myself and other experienced individuals and entrepreneurs will give you your feedback based on their experience, which is great. And then also, if you just want to be a fly on the wall and kind of social listen in on the group, you're going to learn a lot about different cancellation scenarios, and you're going to be even more prepared after you listen to this episode and join the group if something were to come up down the road. That's it. That's all I have for you. Thanks for listening, and I hope to chat with you guys soon.
Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpaige.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.